Hi, this is Karen Cole from Legal Minded Friends. This week I shared with you a question that one of my clients had regarding writing a witness statement or a statement for civil court. And since then, the courts have come out with new practice rules regarding signing a true statement. So in the next video, I'm going to give you a little bit more information about that. I also think because the subject of evidence and giving evidence or producing evidence is very complicated, in the next video I'm going to give you a bit of insight with the subject of evidence. And remember, if you have any legal questions or you have a legal issue that you'd like to speak to somebody from Legal Minded Friends, please contact us, as we are here to help those who cannot afford a solicitor or who have been turned down by legal aid because you make too much money. So please share this information. I hope you found it useful. Thank you.
So when you give a statement to the court, you are giving evidence. And firstly, I'd like to say that the practice directions for signing a true statement now must incorporate a warning that proceedings for contempt of court may be brought against those who give a statement of truth without an honest belief of its truth. So if you're in contempt of court, you could be fined or given a prison sentence. However, the court must look at the evidence, and it should be relevant before the court will accept it into the case. Evidence can be brought in the form of exhibits, affidavits, eyewitnesses, depositions, documents, oral evidence. You could have expert evidence such as medical report, forensic evidence, DNA and fingerprinting. This might be if you're trying to prove that a child is yours or is not yours. You could have character witnesses. They could be good or bad, and obviously the court would want to know if there's any bias before they accept this kind of evidence. And before it's admissible, the court wants to know if the evidence, in whatever form it's in, proves or disproves an essential element. So the court must weigh this up. If the evidence is admissible, then it can become part of the case. Before a witness can give evidence, the court must be satisfied that the person understands the questions that are put to them. And in reverse, the person must also understand the answers which they are giving the court. If a witness retracts their statements or doesn't tell the truth when giving oral evidence, then this would be considered a hostile witness. Any statement given outside the court is considered hearsay unless the person is available to give oral evidence and be cross-examined. Cooperative evidence must support or confirm or strengthen the evidence. Circumstantial evidence is when the fact or a list of facts taken individually does not amount to proof or disproof of something you're trying to prove. And of course, confessional evidence is at the discretion of the judge. And we think of this as when somebody admits to doing something, but they may have been coerced or the evidence just doesn't weigh up to the fact that they're confessing to something. Whenever you're making a claim in the civil courts, you must make a statement And whenever you're trying to defend a case, you also must make a statement. So as you can see, evidence makes up a huge part of whether or not something can be proven or disproven. If you're going to take a case to court, you should make sure all your evidence makes for a strong case. Otherwise, you may have to pay the other side's costs. Legal-minded friends can help you weigh up the pros and cons of either taking a case to court or how you should defend it. Please like and share if this information has helped you or will help somebody you know. Thank you.